two rules that were amended at this Assembly of State Parties. The first one is Rule 134. As you may recall, it was the amendment that we sought to ensure that His Excellency the President and His Excellency the Deputy President would not have to physically appear in court, that they could be represented by counsel if they so wished. So I'm happy to report that the working group has adopted that, that rule as amended. Most of the changes in there were sought and in fact negotiated by the Kenyan team that was here, a team that has done an excellent job, that today received the accolades of all their peers at this Assembly of State Parties. So basically to report that we actually achieved what we had come here to do, which was to amend Rule 134 so that His Excellency the President and His Excellency the Deputy President would be represented by counsel if they so wished and did not have to be present physically at the court in The Hague. The second rule is Rule 68, and Rule 68 involves the use of statements previously made. We have also been able to amend that to ensure that in fact that rule would not be used, the amendments would not be used retroactively, and therefore they could not and will not be applicable in cases that are before the court today, that they are for future cases, if there are any, before the court. So really to just say that we're very, very grateful. We had an extremely excellent team here that worked very well, and we are very proud today that the team has been so recognized by the whole Assembly of State Parties. I'm also happy to report that our team got a lot of support from delegations from our continent that were here, from the African continent. And today at the adoption of these two rules, all of them spoke up in support of Kenya. Therefore, we are also very gratified to have had that support from our African brothers and sisters. In fact, all those that are members that are state party to the Rome Statute. So we're very, very grateful for that. The only other thing that I could mention, just in passing, is the issue on the amendment to Article 27. As we had informed you before, that is an article in the statute itself. It is not a rule of procedure, it's an article in the statute. We gave notice to the Secretary General that we'll be seeking an amendment to Article 27. We have requested for an extraordinary session of the Assembly of State Parties to consider that, because as you may know, after notification, one has to wait for a period of 90 days or 3 months, and therefore you give the notification, wait for 3 months, and then ask for an extraordinary session of the Assembly of State Parties. So we have done both. We gave the notification to the Secretary General, whereas we have also requested the Bureau of the Assembly of State Parties for a date for that extraordinary session of the Assembly of State Parties. So in fact, let me just recap. All that we came to achieve at this Assembly of State Parties, we have achieved. Everything that we sought to achieve, we have achieved. We've achieved the amendment to Article 134 to ensure that the President and the Deputy President can be represented by counsel. We have also been able to ensure that 68 does not apply retroactively. And thirdly, we have also been able to notify the Secretary General of our intention to amend Article 27 of the statute. That can only be done at the next session of the Assembly of State Parties, which will be an extraordinary session and which can be held after 90 days of notification. And therefore, we're hoping that by the beginning of summer latest, an extraordinary session of the Assembly of State Parties will be held. Thank you very much.
Yes, maybe a question that I know would be asked is, how confident are you that you will get the support that you need at the plenary to formally endorse and adopt this
Well, thank you very much. Yeah, that's a good question. Actually, it has never been the practice to reopen language that has been agreed at the working group level. As soon as language is agreed at that level, unanimously, with no objections, with no request for amendments, with no statement objecting or raising any sort of reservation, then in the plenary, it's actually just a matter of a formality, right? To just make sure that it goes through the plenary as well. But it has never, I've never seen it in practice anywhere, actually, not just at the Assembly of State Parties, but at any international conference, that language that has already been agreed at the level at which it was supposed to be examined and agreed. I have never had that language reopened in a plenary session, especially if there was unanimous agreement that in fact that should go forward to the plenary. Thank you.
Thank you.